This video is going to give you an overview of the innovation patent and the process of applying for an innovation patent. Innovation patents are a second-tier form of protection that is particularly suitable for simpler inventions or incremental advances in technology. It is probably easiest to begin with a comparison between the innovation patent and the standard patent. If you haven't watched our video on the standard patent process, it would be a good idea to watch this first. Click this link to be taken there. Now, let's have a look at the comparison. There are many differences between the innovation patent and the standard patent. For simplicity, I'll just talk about the three major ones at first instance. The first major difference is in the term or length of protection available. The innovation patent will give you 8 years of protection for your invention, whilst the standard patent will provide you with 20 years of protection. The second major difference is in the threshold requirements for patentability. To obtain an innovation patent, your invention will need to be novel and to involve an innovative step. However, you will remember that to obtain a standard patent, your invention will need to be novel and to involve an inventive step. The third difference is that in the innovation patent process, examination is optional. In the standard patent process, examination is compulsory. This has a substantial effect on how these patents may be utilized commercially. To help you understand and contextualize these differences, let's now have a look at the innovation patent application process in more detail and what these differences mean in a practical sense. Like with the standard patent application process, you may or may not have filed a provisional patent application to give yourself 12 months of initial protection. Before the expiration of this 12-month provisional period, you must file a complete application to maintain your priority date. In this instance, your complete application would be a complete innovation patent application. Once filed, your innovation patent application undergoes a formalities examination where minor details are checked. These details include things like the inventor names and/or the formatting of the application. Once this formalities examination is completed, your application will proceed directly to grant. If you have watched our standard patent video, you are probably thinking that this doesn't sound quite right. How can my application proceed directly to grant without undergoing examination by the Patent Office? Without examination, how does the Patent Office know that my application meets the requirements for patentability? Well, this is where difference 3 comes in. You will remember that examination is optional for an innovation patent. The term granted when applied to an innovation patent has a different meaning than when applied to a standard patent. A granted innovation patent is not enforceable, whereas a granted standard patent is enforceable. When I talk about enforceable, I mean that if you wanted to sue a copycat, you would not be able to do so unless your patent was enforceable. For your innovation patent to be enforceable, you will need to request substantive examination of the innovation patent. This is formally known as certifying your innovation patent. You can request certification at any time during the 8-year term of the innovation patent. So, why would anyone want an innovation patent that is not enforceable? The simple answer is cost. You may decide that you do not want to spend the money going through the certification process until you need to. For example, you may want to wait until you see that someone is definitely copying you. It really depends on your budget and your business model. Your patent attorney can help you determine an approach that suits you and your business. If you were to request certification, IP Australia will then look at your innovation patent to assess whether your invention is novel and whether it involves an innovative step. Novelty is the same as for standard patents and simply requires that your invention is new in light of anything published anywhere in the world before your priority date. You will remember from the standard patent video that your priority date is the date at which an application was first filed for your invention. Innovative step, like inventive step, is a subjective test. However, the inventive threshold for innovative step is a lot lower than for inventive step. Australian patent law defines that to have an innovative step, your invention must provide a substantial contribution to the working of the invention. This phrase is a bit convoluted, but in practice it generally means that your invention should provide some advantage over the prior art. When I say prior art, I'm referring to similar or relevant inventions that existed before your priority date. As a hypothetical example, consider a typical water bottle with a ridged bottle cap to aid with gripping and twisting of the cap. If you were to introduce the same ridges to the body of the bottle, this may be considered enough to provide an innovative step, because the new ridges provide an advantage in that the bottle may be easier to open. On the other hand, this type of simple improvement may struggle to meet the inventive step threshold for standard patents, as it may be considered obvious to take the ridges from the cap and place them on the body of the bottle. You will remember from the standard patent video that to have inventive step, your invention cannot be considered obvious to a person skilled in the technical area of your invention. Your patent attorney can provide you with some guidance as to whether your invention may meet the innovative step threshold. After reviewing your innovation patent, the examiner will issue an examination report, providing an opinion as to whether your invention is novel and whether it involves an innovative step. From the date the first examination report is issued, you will have 6 months to put your innovation patent in order for certification. This may involve several responses to the Patent Office. Once the scope of your patent is settled, such that it meets the threshold criteria for patentability, your innovation patent will be certified. Your innovation patent is then enforceable. The low threshold for inventiveness means that innovation patents are particularly suited to simpler inventions and incremental improvements. Although the innovation patent protects small advances, it can be a very powerful commercial tool, as it can be enforced in the same way a standard patent is enforced. The optional examination also makes it commercially attractive to small businesses. As always, if you're unsure if an innovation patent is right for you and your business, your patent attorney can sit down with you and discuss the pros and cons. We hope this video was helpful, and if you have any particular questions about innovation patents, feel free to get in touch with us at Davies, Collison, Cave, and we will be happy to help you out.